constitutional analysis for less than what I would expect from a first-year law student. They left out landmark cases, total intellectual dishonesty. And finally, hatred is at the heart of the House manager's frivolous attempts to blame Donald Trump for the criminal acts of the rioters based on double hearsay statements of fringe right-wing groups based on no real evidence other than rank speculation. Hatred is a dangerous thing. We all have to work to overcome it. Hatred should have no place in this chamber in these proceedings. The second observation. The Senate is presented with an extraordinary task sitting in judgment of a former president's words in a speech that he gave at a political event. The House managers accused Mr. Trump of using his words to incite the horrific events at the Capitol on January 6th. But yesterday, they gave you a new and novel standard of incitement with an element of foreseeability, a negligence concept. They cite zero case law. They made it up. This task of applying a completely made-up legal standard of incitement to an impeachment proceeding is truly an unprecedented task for the Senate. And that is something the Senate must seriously consider when deciding the issue. Do you want to create a precedent where the Senate will be tasked with sitting in judgment as to the meaning and implied intent of a president's words? Or words of any elected official? Will that allow and maybe encourage a majority party to weaponize the awesome power of impeachment against the minority to suppress a point of view? Will the Senate then have to deal with constant articles of impeachment by a majority party accusing minority presidents or other elected officials of so-called insightful or false speeches? You can see where this would lead. Sadly, we have all seen the political rhetoric get ratcheted up over the last few years. We've all been witnesses to many incendiary words by our officials at political events, broadcast over the media, internet. In each of those instances, will there now be Senate impeachment hearings? One last observation. We agree with the House managers, context does indeed matter. The inflammatory rhetoric from our elected officials must be considered as part of the larger context of Mr. Trump's speech at the ellipse on January 6th. The inflammatory language from both sides of the aisle has been alarming, frankly. But this political discourse must be considered as part of these proceedings to contextualize Mr. Trump's words. We have some video to play that highlights some of what I'm talking about. I preface this video by noting I am not showing you this video as some excuse for Mr. Trump's speech. This is not whataboutism. I am showing you this to make the point that all political speech must be protected.
I just don't even know why there aren't uprisings all over the country. Maybe there will be.
There needs to be unrest in the streets for as long as there's unrest in our lives.
You gotta be ready to throw a punch. You have to be ready to throw a punch.
Donald Trump, I think you need to go back and punch him in the face.
That I thought he should have punched him in the face.
I feel like punching him.
I'd like to take him behind the gym if I were in high school. If I were in high school, I'd take him behind the gym and beat the hell out of him.
No, I wish you were in high school. I could take him behind the gym.
I will go and take Trump out tonight.
Take him out now.
When was the last time an actor assassinated a president?
They're still going to have to go out and put a bullet in Donald Trump.
Show me where it says that protests are supposed to be polite and peaceful.
what they do.
I want to tell you, Gorsuch. I want to tell you, Kavanaugh. You have released the whirlwind, and you will pay the price.
We're going to go in there, we're going to... This is just a warning to you Trumpers. Be careful. Walk lightly. And for those of you who are soldiers, make them pay.
If you had to be stuck in an elevator with either President Trump, Mike Pence, or Jeff Sessions, who would it be?
Does one of us have to come out alive?
Again, I did not show you their robust speech to excuse or balance out the speech of my client, for I need not. I showed you the video because in this political forum, all robust speech should be protected, and it should be protected evenly for all of us. As a brief aside, we should all reflect and acknowledge the rhetoric has gotten to be too much and over the top. It is grating on the collective well-being of the body politic, the citizens. Most would like it to stop. But the point is, when you see speech such as this, you have to apply the First Amendment evenly. Blindly. She is blind, Lady Justice. Question 1. Does the First Amendment apply to this chamber in these proceedings? The House manager's position, as stated in their trial brief, is, and I quote, "The First Amendment does not apply at all to an impeachment proceeding." That's their position. This is plainly wrong. The text of the First Amendment expressly restricts Congress from regulating speech. It says, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances." To ignore the Constitution would be contrary to the oath of office of a United States Senator. I do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same. Well, you all know the rest. No, the Senate cannot ignore the First Amendment. The Constitution itself limits the ability of the House to impeach to limited items, such as high crimes and misdemeanors. The position advanced by the House managers is essentially an unlimited impeachment standard without constitutional guardrails, unmoored to any specific legal test other than the unbridled discretion of Congress. This is distinctly not the intent of the framers. The framers were aware of the danger of any impeachment process that would make the president the mere creature of the legislature, a quote directly from the framers while debating the impeachment process on the floor of the Constitutional Convention of 1787. The framers were fearful that any impeachment process that gave Congress full discretion on the standard for impeachment would constitute nothing less than a violation, quote, a violation of the fundamental principle of good government. One founding father, James Wilson, wrote extensively on the impeachment process. Mr. Wilson was a renowned legal scholar at the time, a law professor at the University of Pennsylvania in Philadelphia. He was a major force in drafting and adopting the Constitution in 1787. He served as one of the first six Supreme Court justices, 1789 to 1798. He was appointed by President George Washington. In fact, Wilson taught the first course on the new Constitution to President Washington and his cabinet. The first in the nation's history, in Philadelphia, at the University of Pennsylvania in 1789. Wilson, in his law lectures, the first of their kind under the Constitution, plainly states that the Senate may not ignore the Constitution in impeachment proceedings. He states that lawful and constitutional conduct may not be used as an impeachable offense. Let me say that again. He states that lawful and constitutional conduct may not be used as an impeachable offense. Read along with me. The doctrine of impeachments is of high import in the constitutions of free states. On one hand, the most powerful magistrate should be amenable to the law. On the other hand, elevated characters should not be sacrificed merely on account of their elevation. No one should be secure while he violates the Constitution and the laws. Everyone should be secure while he observes them. To be clear, James Wilson is saying that the Constitution does indeed apply when judging whether to convict an official by impeachment. If the complaint of conduct is constitutional, it cannot be impeachable. Are we to ignore the words and teachings of James Wilson? The House managers surely want you to. The House managers have made several references to this letter, signed by 140 partisan law professors, calling Mr. Trump's First Amendment defense legally frivolous. This is really an outrageous attempt to intimidate Mr. Trump's lawyers. Whenever a lawyer advances a truly frivolous argument, they may violate professional ethical rules and could be subject to discipline. This letter is a direct threat to my law license, my career, and my family's financial well-being. These law professors should be ashamed of themselves, and so should the House managers. How dare you? Do you really hate Donald Trump so much that you're willing to destroy good, hard-working people's lives, people that are only doing their jobs, and frankly, as counsel for an accused fulfilling a constitutional role? It's astounding, really. I'm a citizen, not a politician. I know these First Amendment arguments are not anywhere close to frivolous. They are completely meritorious. Interestingly, the law professor's letter was issued on February 5th, 3 days before we even filed our legal brief in this matter, and they ignored landmark, bedrock Supreme Court cases directly addressing this issue. In our brief, we have a direct quote from James Wilson, the founding father, supporting our position. The direct quote was documented in the founding fathers' original legal papers. Do I have those with me? On the subject. He was the primary draftsman of the Constitution who taught the new Constitution to President Washington. He says so long as acts of elected officials like Mr. Trump are constitutionally protected, he should not be impeached. We have landmark U.S. Supreme Court decisions, Wood and Bonds, which I'll explain in detail, supporting our position. All of this, the House managers and the partisan law professors completely and misleadingly ignore. Frivolous? Hardly. The letter is a bully tactic, and I think evidence is the House managers know they have a problem with the First Amendment defense on the merits, so they're resorting to such tactics. The House manager's suggestion that the First Amendment does not apply to this impeachment process is completely untenable. Ignoring the First Amendment would conflict with the senator's oath of office. It would also conflict with well-settled Supreme Court precedent and ignore the intent of the framers of the Constitution, such as James Wilson. Above all else,
currently watching
ignoring
day
the
4 of the
Constitution.
second impeachment of former president, now private citizen Donald Trump. House managers wrapped up their case yesterday, and today is focused on the defense. We just heard from Trump defense lawyer Michael Van Der Veen. For uninterrupted coverage of the impeachment trial, you can go to our Facebook page at facebook.com/Real America's Voice. We'll be right back.